of property from a foreign seller to withhold tax from that transaction. And it's important to realize on these that the buyer is the withholding agent, not the settlement agent, even though as a practical matter, Paramount and other settlement agents will be the ones that will withhold those taxes from the sale, and they will be filing the forms with the IRS. The buyer is the actual withholding party, and it is important to realize for buyers at the end of the day, especially in situations where an exemption or something outside of the ordinary is done, it's the buyer's liability at the end of the day, not the settlement agent's. And sometimes it is the responsibility of the seller to pay the tax, but unfortunately, sometimes with foreign sellers, you can't locate those sellers. They're out of the country and hard to find. And if the IRS comes down and decides that taxes are due from a seller and a buyer, and they're unable to find a foreign seller, guess who they're going to come to talk to collect their taxes. So what you're going to see for the most part from a sales associate basis is the sales contract provisions are the first indication that you're going to have with respect to FIRPTA. And excuse me, I just added some of the provisions from a FAR standard contract. You've got a disclosures paragraph, and this is kind of fine print on a PowerPoint, so I'm not going to ask anybody to read this as an eye test. But in short, you've got a disclosures paragraph where you've got a requirement for the parties to disclose whether the seller is a foreign person, and you also have standards, which is in every FAR contract. And on this next page, I've got just a summary of what those provisions are in your sales contract. You've got a requirement that the seller shall inform the buyer in writing if the seller is a foreign person. You've got a requirement that the buyer and seller shall comply with FIRPTA. Importantly, a seller may be required to provide additional cash at closing. You may have a situation where the property is completely levered up. The mortgage amount is almost exactly what the sales price is. Seller is walking away from the property with no cash in his pocket and in their pocket. But if that's the case, they may have to come out of pocket to fund the withholding that the buyer is going to have to do for the 15%. So it's good that that is in the contract. And these contracts have been around a while and negotiated with the bar and the realtors. So it's very, very good that that's in there to let the seller know that they may have to come out of pocket for that withholding if they do not have enough liquid proceeds as a result of the closing. It also provides that there is no withholding if the seller provides the buyer a certification of non-foreign status. And that's a form that's pretty popular. There's a lot of them out there, and it just really says that you are a non-foreign citizen, and generally provides that you put a social security number or you're a U.S. citizen or whatever other basis that you are a U.S. person. If no certificate is provided, if no exemption applies, and no withholding certificate is issued by the IRS, the buyer is required to withhold. We'll talk about all of those as part of the presentation today. And in the other situation, if a withholding certificate is applied for, so say, for example, you have a sales contract, you have a foreign citizen, they think they're not going to make any gain on the property, they have the ability to ask the IRS to provide a withholding certificate saying, look, I'm not going to make any money on this deal, so I'd like to tell you that the buyer, I'd like to get a withholding certificate from the IRS to say that they don't have to withhold anything because I'm not going to make any gain on this property. In that situation, if the IRS has not come back and provided that information and that confirmation, the buyer must withhold. And this is the important part of this, and may, not must, but may, escrow funds pending IRS issuance of the withholding certificate. So even if the seller has applied for withholding certificate from the IRS, and at closing that has not come back yet, the buyer is not required to escrow those funds pending issuance from the IRS of that certificate, but that's something that should be negotiated between the parties, between the seller and buyer. And then finally, it requires that once the buyer has remitted the funds to the IRS, that the copies of the forms that they've filed are provided to the seller. So the borderline question here, or the really important question is the seller a U.S. person? Because if the seller is a U.S. person, no withholding is required. So for individuals, that the U.S. person is a U.S. citizen, that is a U.S. resident alien holding a green card, and it is a U.S. resident. This is a non-citizen, but they can pass the substantial presence test, and we're going to talk about that in a few minutes. And with respect to entities, you've got LLCs, you've got corporations, you've got trusts, you've got partnerships, and a little bit different rules on each one. And I would caution anyone out there that you do not want to be, unless you're a tax CPA, you don't want to be the one advising a party whether they are a U.S. person or not. That needs to be done through, if there's any question on that, that needs to be done through a tax CPA. Okay, and I'll just go over some of the rules here briefly, just so you have a lay of the land here. For LLCs, they've got a special rule on these. So on any LLC, you're going to disregard the LLC form of ownership and look to the status of the member if the LLC is a single member LLC. And so then once you find if it is a single member LLC, you're going to go through the process of seeing whether it is a U.S. citizen, a U.S. resident alien holding a green card, or a U.S. resident, or a resident that passes the substantial presence test, just like an individual.
And Alan, if I can intervene just really quick, this is a really, I just wanted to kind of touch on this a little more. This is a big reason why we ask for the sellers to contact a CPA so that they can fully determine if in fact FIRPTA does apply, and they can assist them with filing their documents for FIRPTA, filing their withholding certificates if that's the route they choose to go, et cetera. So this is a big reason why we don't prepare these documents for closing for FIRPTA. We ask them to get with the CPA to do those. So we're protecting the buyers, the sellers, and everybody involved. And Uncle Sam isn't coming back and looking at us wanting to know where their money is at later down the line. So
I'm glad to hear that, Sean. That's a really prudent way to handle your business. And like I say, when you start reading through these, and I'm just giving this hour presentation, if I make an hour, this presentation is just a kind of an overview of what's going on here, because when you start digging into this, this is, after all, a tax statute. And anybody that reads through tax statute, they're always referred to as five-finger statutes. When you looked at a statute book, you usually had to have one provision, and you had to look at another provision, and you had your five fingers in the book that go back and forth to figure it out. And they're very, very arcane and very complicated. So thank you for that point. So just briefly talking about entities, if you're looking at a corporation, they look first, the first question you ask is, was a corporation created or organized in the United States? If it is, it's going to be looked at as a U.S. person. If it's a foreign corporation, they can become a U.S. person if they elect to be treated as a domestic corporation. Okay, so the offshoot of this is, Sean is absolutely right. You're going to want a CPA to take a look at this. CPA is going to have to tell the closing agent what the status of this company is and how the withholding is going to be done. But just for your, back of the napkin kind of thing, if you've got a foreign corporation, but they've elected to treat themselves as a domestic corporation and be taxed as a foreign corporation, you may be able to get the CPA to bless them as a U.S. corporation for the purposes of your transaction. Partnerships, a little bit differently. Generally, if it's a foreign partnership, you're not going to be able to get that U.S. treatment. With respect to a trust, you may be able to, But in those situations, the U.S. court would need to be able to exercise primary supervision over the administration of the trust. And generally, is the person authorized to control all the substantial decisions a U.S. person also. So in a trust situation, yeah, it may look like a foreign trust, but it's going to be U.S. for most other purposes, for the primary supervision by the courts and for substantially all the decision making. So very, very narrow room to maneuver there for a trust to be able to be a U.S. person where foreign entities are involved. So we'll talk briefly about the substantial presence test. And again, just to reiterate Sean's point, that's not something that you want to determine. It's something that if somebody comes into you and says, yep, I want to use the substantial presence test, run screaming into the CPA's office and don't put yourself out there and say, yeah, I think you apply, or I think this applies to you. Not your job, not what you want to be doing. So, and that being said, in general, substantial presence test is you'll be considered a foreign party, would be considered a U.S. resident for tax purposes. If they meet the substantial presence test, they would have to be physically present in the U.S. 31 days during this year and 183 days during the 3-year period that includes the current year and 2 years immediately before. The trick to this is that not all the days count the same. So all of the days from 2000, for this example, all the days from 2021 would count that they were here for this year, but only a third of the time that they're here is counted in 2020, and only a sixth of the time they were counted the year before. So it's kind of a complicated calculation. But again, it is possible, and it is one of the exceptions on the statute. So we didn't want to have that out there for you to understand it was out there. There is also a residential exception to the statute. This is the sometimes people call it $300,000 exception. And this applies with your seller is definitely a foreign person. They're not going to apply. They're not going to. The buyer is required to withhold because the seller is a non-U.S. person. But where the property is under $300,000, they may be able to avoid withholding if the buyer is an individual, property is acquired for use as a resident, the buyer intends to reside on the property 50% of the days in each of the first 2 years. And this is the important, and this is the rub here for this exception. The buyer is not required to do this. Even if all of this is true, the buyer may say, well, I don't think I want to use this exception. I want to withhold anyway. And you'll know back when I talked about the contract, the buyer is not required under the contract, even if these are all true and they do intend to reside on the property going forward, they don't have to provide this exception to the seller. Okay, and it's kind of dangerous. I know if I was representing a buyer, I would be very hesitant to have my buyer sign off on one of these and not withhold. Let's see. And Sean, I have a hand raised here. Let's see.
I see that. It looks like Deb Haley. Deb, did you have a question?
Let's see.
We don't
You
recommend.
can give her permission to talk.
Yeah. Oh. Okay. I'll look back through the participants. She said we don't recommend this buyer doing this. Is that signing the affidavit? Let me find you, Deb. I'm sorry.
I got her. She can talk now.
Thank you.
Oh, hi.
Hi.
So we do deal a lot with this here in Sun City Center with our Canadians.
Mm-hmm.
And yeah, we try to dissuade the buyer from signing these because it does give them the liability. And a lot of times they're snowbirds. And sometimes they're down here and then they get ill and can't come back. I mean, we try and dissuade them from signing this, but sometimes they do.
Just a question, Deborah, as part of your negotiation, do you ask the seller to sweeten the pot a little bit for the buyer to execute this?
We would now. In the past, we really haven't too much, because they're already, the seller is already, we get yelled at from the sellers because they don't really realize this, especially if they've had houses here for any length of time, and they've never been a resident here. But that is an excellent idea. I think it's an excellent idea to do that. And I think going forward, when the snowbirds start coming back, when the Canadians start coming back, we should do that. I mean, that's an excellent idea.
Yeah, because I agree with you 100%. I agree. I don't think I would recommend to my buyer that they do this, because unless they're compensated in some way, shape, or form, because as I note here, if the residency is not maintained, even if the buyer has every intent on living here or having their children live here or having some family member live here, things happen.
Yeah.
And if the IRS gets wind of that and comes back, they're going to be looking for somebody to pay that tax. Buyer and seller are both liable. And generally a seller who's, it's a single property and they live in, Hungary or something, it's very difficult. The IRS is not going to go to look for the foreign sellers. They're just going to go for the low hanging fruit and go after the buyers.
Absolutely. And it's a $200,000 sale. It's a $30,000 hit. A lot of times, it can be.
And I'm sure they're going to come after penalties on that as well. So
Yeah. So we try to dissuade, but sometimes they're okay with it. Sometimes buyers, they really want the house. And in this market, we're probably going to see more buyers sign this just to get the house.
Understood. Sean, I appreciate you having me here today. Your audiences are usually well informed. I don't know why I even presented these things. They usually know the answers before I give them.
Because we have a lot of new agents.
this is great. No, I love this. We've got a lot of people on, and this is good information. So.
And one thing I do make this residential exception. They've got to reside on the property 50% of days in each of the first 2 years. But and I'm not sure if I got a myth in here too. The buyer doesn't actually have to live there as their principal residence. Okay, so their family members can live there, or some other exceptions there too. So it doesn't have to be the buyer only living there for the first 2 years. So if you do start looking into this, you may want to inquire of your CPA as to what the other options are for residents there. If you do get into a pickle and the buyer isn't able to live on the property, there may be other ways to comply with this. So
I have a question. Does that have to be a primary home to the buyer, or can it be a vacation home?
that's what I'm saying. It does not have to be the principal residence.
Oh, okay. Okay, good.
Okay, we're going to talk a little bit about foreign decedents here. This is kind of scary. I was looking through this, and the more I read it, the scarier it got. By the way, we've got a bulletin out there that you can take a look at. And so the first thing we talk about here is foreign decedents receive an exemption from federal estate tax if the aggregate value of the foreign decedent's taxable U.S. assets do not exceed $60,000. And I think for a U.S. resident, I think it's up to like 11 million. But for a foreign decedent, it's 60,000. So chances are, if you've got substantial gains for a property, it's not going to be exempt from estate taxes. If taxes owed, taxes are usually paid within 6 months of the decedent's death. That's required. And you're going to need a transfer certificate and an estate tax closing letter before the deal can be closed and the money is dispersed. Okay. And they've got something called a statutory executor. And that's one of those fun IRS terms. And I've got here agent liability, which I mean in the broadest sense, because agent liability may go to sales associate agents, may go to closing agents, may go to other parties here, because as is the IRS, the terms are not clearly defined, and they're defined loosely, so they create a bigger net for more people to fall into them. So, and you're really going to have problems on these when you have transfers by survivors. Say you have an estate by the entirety. Say you have two parties that own a property, a husband and wife, and perhaps the husband is a foreign resident and the wife may not be, and the husband may die first, and the wife then is selling the property. You may have a situation where the IRS may look behind that estate by entireties and the transfer by operation of law and say that you're going to need to withhold the fractional portion of the property that's owned by the foreign decedent. So if you've got a death situation, be very, very cautious. Okay, I've got a useful tips here page. Quitclaim deeds. That's more of a question and answer. I think somebody put that in and I put it in the slide here. Somebody had asked, hey, if I use a quitclaim deed instead of a warranty deed, can I avoid liability? Sean, what's your answer?
That's called tax evasion. I'm so glad you put that there. I was going to actually say that. So yes, no, that's not allowed.
I
I don't
appreciate
wear orange
that.
very well. I don't know about you. And I won't sport a 4x4 cell very well either. So
So gifts, they're still taxable. So you're still going to have to go through the same hoops with a gift as you would with a sale. 1099s are always going to be issued to a foreign seller. If withholding is required, you're always going to remit the 15% to the IRS, even if the agent is not provided with a tax identification number. Sean, question going backwards to you. So since you're helping me with this, I appreciate it. How many transactions do you get in where parties just refuse to give you a taxpayer identification number? Is that a problem?
occasionally, and we just hold their feet to the fire and tell them, unfortunately, we can't move forward because it is an IRS requirement and we're required to report by the IRS that we have to have it. And we usually get it. We usually don't have any issues with that.
Excellent. Thank you for that. That's, it's one thing for me to talk about it from an underwriter perspective, but with you, with your ears to the ground and much closer to the ground than me, it's nice to get some of that feedback. Thank you.
Now, I do have a question for you from a title perspective. On the 1099s will always be issued to foreign sellers. We were actually instructed by our CPAs that use, or that we use and recommend, some sellers to use. We have some contacts there for them, that we don't issue a 1099 on this. They actually get, I think it's a 1042 or something like that from them directly, because they're not US citizens. We can't 1099 them for the sell. Do you know any? Maybe
this is more a generic presentation. Okay. I am certainly not a tax expert, and so Sean, I would certainly recommend that you follow the advice. I was
curious on your take on that, so no problem.
Yes. Thank you for the question, and I'll take that out of the slide here because, like I say, I'm an attorney, I'm an underwriter, but I'm certainly not a CPA and a tax.
Not a tax professional. I understand. Me either.
Yeah, and that's the funny thing about working with real estate too. You always have that confluence of tax issues and dirt law and estate law, and it's all kind of melded into one big pot that you can't know everything. Yep. So some of the value of these chats. So bottom here, agent should never, ever prepare a W-7 requesting a TIN. Again, because that's part of that statutory executor. You don't want to become an agent of the seller, which may create some liability on your part. I've got review bulletin SLS 2016-001. That's one of the Stewart bulletins on virtual underwriter, for those of you not familiar with that. Our virtual underwriter site on Stewart.com is free to the public, no passwords required, and that is a nice bulletin there, especially when it comes to decedents, because it talks about some of the transfers for and what you need to insure over a transaction where you have a foreign party who is deceased. So I'm going to end this up. I've got about 5 frequently asked questions and myths I'm going to go through just quickly. One question is, seller's making no profit on the sale, so you don't need to withhold, right? Well, that's not correct, because the withholding is based on the contract price. It's not based on the profit or the loss or the established loss, because as we all know, establishing gain or loss on a piece of property is a time-consuming process in terms of you have to figure out what the depreciation is and what expenses they have and things which I'm certainly not qualified to do, and I think most of our closing agents are not, and nor would they want to do and try to figure that out. There's no automatic exemption from withholding if the seller is taking a loss or they're realizing no gain. So it's the settlement agent's job is to withhold on behalf of the buyer for the 15%. And I'm going to talk about a question later, but if the seller does not want the amounts withheld at closing, that's solely within their province, because they can apply to the IRS for withholding certificate. And if they do it in time, the withholding certificate is back in the closing agent's hand by closing. And if there is no tax due and the IRS agrees with that, that's what the withholding certificate will say, and the closing agent will be able to proceed using that withholding certificate. And here I'm going back to that question I asked you earlier, Sean. Does the seller doesn't need a Social Security number or a title identification or taxpayer identification number? And this old Treasury decision from 2003 requires all transferees and transferors to provide tax identification numbers. Names and addresses should be found on applications for withholding certificates, notices of non-recognition, or other elections. So, and I've got down there, seller needs to submit a W-7. A W-7 is the form that you would give to a foreign party who does not have one of those numbers, because that is the form they need to fill out and submit to the IRS to obtain a Social Security or taxpayer identification number. Generally, a taxpayer identification number for a foreign party. And we talked about this earlier about the sales price of the property is under $300,000. Buyer is going to live in the property. Doesn't that automatically exempt it from withholding? And Sean, can we open up all the microphones so all at one time we can all say, I'm just teasing, I'm just joking with you, but no, it's not automatic. We talked about this before, and I really appreciate the practices in the room here. So, but an intent to reside statement should be obtained. Sean, is that what you guys do? You have an intent to reside form or an affidavit that you make the buyer sign?
We do.
That's a good practice. They're not required to sign that, but I don't know that I'm going to want to close my file, have no withholding for that buyer with nothing in there with the buyer's blood on it saying, hey, we're going to reside on it. That's why you're not withholding.
If we are not collecting, we absolutely have them sign. It's either they sign it or we collect. So.
Very good. And, that protects you, that protects your sales associate. And at the end of the day, it's better for the buyer too, because at least it provides some stability. Everybody knows what would happen there. We have a signed written statement. And it's amazing what people forget after the fact when the IRS sends them a letter. I didn't mean to do that. All right, seller does not need to file a tax return if the withholding is zero. Well, that's not true. Issuance of a withholding certificate that says that there is zero withholding and none is taken, it doesn't change, doesn't do anything to the filing requirements for that foreign seller. They are still going to have to file a return at the end of the day, showing that they transferred that U.S. real property interest. The fact that they don't have to pay taxes with it, well, not our problem really, because we're out of it by that time. But they're still going to have to file a return, and the withholding certificate does not change the requirement that they file a return at the end of the day. Here we've got a situation, a question where the transaction was from a foreign seller to a foreign buyer. Is that exempt from withholding? Well, no, really doesn't change anything. You've still got a foreign seller transferring a U.S. real property interest. The fact that the buyer is also a foreign person doesn't change those requirements. So both parties are required to have a TIN, and withholding required if no exception applies. So in that situation, you're generally not going to have a situation where the 300,000 exception is going to apply in other matters. But the fact that both parties are foreign is not going to automatically exempt you from the withholding requirements of FERPTA. Myth. Funds must be remitted to the IRS within 20 days of closing, no matter the circumstances. No, that's not always true. It's generally true if there are no withholding certificates applied and no exceptions, nothing else going on. So it's just a standard routine closing. You've withheld the 15% and it needs to be sent to the IRS. Yeah, you have to get it to them within 20 days. In the other situation where your seller has applied for an IRS certificate, the parties have agreed that they're going to escrow the funds pending the IRS's decision on the withholding certificate. And you know that that decision is pending with the IRS. Buyer has agreed to escrow the monies. In that situation, the closing agent is not required to submit the funds and the documents to the IRS until the IRS has rendered a decision one way or the other. Either they issue a withholding certificate or they issue a denial of that and say that all the taxes, all the 15% is due. And at that point, the 20 days starts running again, and the transfer agent would be required to remit within 20 days of the IRS decision. Sean, is that all in? I'm seeing you shaking your head. Is that all in agreement with what you understand the
It is.
requirements to be?
It is. I just wanted to add to that, though. Typically, the withholding certificates pre-COVID were taking about 90 days to get those. And now with COVID, it's taking anywhere from 6 months to a year to get those withholding certificates from the IRS. So a substantial amount of time is going by before we get those, which means we can be holding, thousands and thousands of dollars for your seller until we receive that. And I know that gets frustrating for them, but I just wanted to kind of put that out there so that they can be aware of the timeframes and the length of time it can take for us to get those from the IRS. So.
And are you routinely holding those pending the past the closing, pending the withholding certificate?
We do. We hold them in escrow per the CPA's requests and requirements. And then once the withholding certificate comes in, the CPA notifies us and we release the funds within the 20 days at that point. So we have a follow-up system that we do. We follow up with the CPA usually after 90 days, we start following up, even though it's still taking them longer, just to make sure nothing falls through the cracks in the interim, so that they get us that certificate as soon as it comes in.
That sounds like a very, very wise plan here. And one thing I just want to point out to that, if you look at the sales contract too, the escrow, it doesn't have to be free. The buyer can ask the seller to pay the costs and expenses of holding that escrow as well. So just something to consider if you've got a problematic case, you may want to put in there that reasonable fees, costs of holding that escrow are to be charged to the seller at the end of the day there. How does the seller get their money back if they don't owe the entire 15% withheld and tendered to the IRS? Well, it can be avoided by obtaining a withholding certificate prior to closing. Otherwise, if they don't file a withholding certificate, either have the certificate issued by the IRS prior to closing or do an escrow agreement like we've discussed and get a withholding certificate after the fact and not have the money submitted. Otherwise, they'll get their money back, so refund when they file their return that they're supposed to file, and hopefully do file. And I'd like to see the certificate of how many sellers do not file at the end of the day. And finally, that's the end of my myths and frequently asked questions. And somebody needs to talk to me about my spelling, because I don't think useful is spelled that way. And I apologize to everyone for that. That's my fault. I'm sure it was my spell checker's fault. It wasn't your poor author's fault. But here are some useful sites. If you have questions on these, I've got several of the forms here. I've got the general IRS website. I also have some site to guarantee company information. I've got the bulletin that I referred to earlier. We do have a form for a certification for non-foreign parties, both individually and both individuals and entities. I also included this is not an endorsement of this company, but this is a CPA office that we have used in the past. I'm sure, Sean, you have this one and other ones that you've used in the past as well. I just put this in there just as a drop if somebody is desperate, they need to find something. Here's someone that they can call. Roberge's office has been doing this for probably 20 years. So they are very talented. And like we say, when in doubt, ask a CPA. Don't go on the hook. Don't make that decision and try to evaluate these statutes and make a decision on your own. That's what the tax CPAs are for. So with that, my presentation is at end, and I want to thank everybody for taking the time to listen to me babble on about this, and thank you so much.
Well, we appreciate it. We do have a couple of questions if you've got a minute longer.
Of course,
one of the
sure.
questions is, a seller with dual citizenship living outside of the country, is a seller with dual citizenship living outside of the country considered a foreign seller?
Do they have a social security number?
It's a good question. What if they do have a social security number?
Well, I'm going to give you two answers. If you pushed me into a corner, held a gun to my head and said, you got to answer the question, I might say yes, because they have a social security number and they are a U.S. citizen. But at the end of the day, I'm not going to go on the hook and tell you that answer, because, that's something that a CPA is going to have in that particular answer, in that particular transaction, needs to say, yep, they're a U.S. citizen.
I would always refer them to a CPA if that were the case, just to solidify and confirm whether or not they truly are required to pay the tax or not. So everybody's protected there. And then the other question is, let me scroll up here. If the seller doesn't provide a social security number or a TIN number, is the seller in default of the contract or other mechanism for returning escrow to the buyer? Best practice for the seller to apply for withholding certificate in advance of listing. So I don't know about the being in default of the contract, but the best practice for applying for a certificate, again, would be to reach out to a CPA and start that process even at the time of listing, I would say. Would you agree with that, Alan?
Oh, as soon as possible. Absolutely. And you're right. You indicated earlier and that's what I've heard as well. They used to take about 90 days to get those withholding certificates back, but with all the stimulus checks and the staffing issues at the IRS, they're taking much longer. And so the sooner you get that out, the better.
Yep. But just to kind of put that even more so in perspective, in some of the checks that we've even sent in on the FERPTA withholding that we've gotten back, they're 3 months out and they still haven't cleared our account. And typically they clear within a week. They're quick about cashing those checks, but they're really behind. They're very limited on staffing, and a lot of their staff is still working from home. So it's creating a backlog for sure and getting those things taken care of. And I think that is the only questions I have. Do we want to open up the floor if anybody has any questions? Chris, I don't know if you're the one running the training room, and I'm sorry if that's not Chris running the training room.
No, it's Mike. But
Mike, sorry, Mike.
yeah, if we're no, it's all good. If we are good to go, yeah, we can shut it off. But if there's any other questions, make sure we ask them now.
Yep. And then Alan, also, will you, can you send us a copy of your presentation or some information to go along with your presentation that we can share with the agents just to refer to?
The presentation is public record, basically. I'll have that to you in a few minutes, Sean.
Excellent. Okay. And we'll get that out to everybody as well. I'll get that over to Ange and she'll get that out to the team. So.
Excellent. Again, thank you, everybody.
All right.
Awesome.
Well, I think
Thanks, everyone.
that is it. We appreciate your all's time this morning and hope you guys have a great rest of your day.